Good morning to all of you. Welcome to Legal Matters by Sai Baba Sukar. An important point, particularly for the police and prosecuting officers. The case decided by the Honorable Supreme Court of India says killing civilians in plain clothes. Killing civilians in plain clothes is not part of police duty. Peculiar decision, but very important decision. You have to be reminded of D.K. Basu versus State of West Bengal 1996. Whenever you arrest a person, you have to disclose your identity. You have to be uniform. Whenever you discharge your duty, you have to be uniform. But of course, our friends may get a doubt. Suppose when you are mufti, if some information comes, what to do? That question is unanswered now. Anyway, Justice Vikramnath and Sandeep Mehta bench of the Honorable Supreme Court of India, in the case of Head Constable Raj Kumar, etc., Head Constable Raj Kumar and others versus the state of Punjab and another. SLP number 8656 and 8657 by 2019. Of course, the case was decided in the month of April itself, 29/4/2025, wherein the Honorable Supreme Court of India refused to exonerate the Punjab police officials. Why? In a case of alleged fake encounter of killing Mukjit Singh or a civilian or a truck driver, while police are in plain clothes. I will read the headline once again. Killing civilians in plain clothes is not part of police duty. Right. Of course, here the main point is they came to the court, High Court and Supreme Court for quashment of the proceedings registered by the Special Investigation Team, SIT, against them. Quashment, under 482 CRPC. They refused to quash the petitions because, no doubt, another important point raised by the police is that sanction under section 197 CRPC is essential for prosecuting a police servant, a police officer. But here, the point is police targeted the deceased using their official arms or with rifles they have. So, and they are not in uniform. So, we can't say there is a connection, there is a nexus between maintaining the public order and also effecting a lawful arrest. Coming to the facts in issue, on 16/6/2015, around 6:30 p.m., an encounter took place. So, this happened in Verka near Amritsar or Amritsar district. Actually, the police party, while on patrolling duty, they intercepted an Hyundai i10 vehicle near NRC rubber factory, Verka. And when the people tried to run away, and when the driver objected, when these people actually accosted him, he did not give a proper reply. He threatened them, and as a result of which they killed the driver Mukjit Singh by opening fire with the rifles. And incidentally, this was witnessed by the complainant, Purposive Singh, and another going on a motorcycle, and they raised hue and cry, or they raised an alarm, with which the local residents came there and the fact came to light. Here, very important thing. They informed the DCP came there, and the DCP came there with additional force and asked the police party to remove the number plates before the people take photographs. Right? So, no doubt, Actually, police registered a case in crime number 242 by 2015 under section 307 IPC and also 25 and 27 of the Arms Act against Mr. Mukjit Singh, who died. But since the public came there was a lot of crowd gathering. Ultimately, it has become an issue where the SIT has to investigate the case. Because even though the police say that Mukjit Singh is a part of a Gangster Jaggu case, Jaggu gang, but there was a resentment against the public. Therefore, to satisfy the public normal, the politicians, the government, they will institute NIA, CBI or SIT. SIT formed, and SIT found that the DCP and 7 others, Raj Kumar and others, they are responsible for the death of a civilian in Mafti. So, a case of 304 read with 34 IPC, that is culpable homicide not amounting to murder, is registered against the police officers. And more than that, the relatives of the deceased Mukjit Singh, they filed a private complaint under section 302, 341, 201, 148, 149 and 506 of the Indian Penal Code. Of course, both cases, they are likely to be clubbed together. In this private complaint, the police wanted exoneration under 482 CRPC, saying that prosecution for sanction or sanction for the prosecution is necessary. Please remember, here the private, both of them were clubbed and summons were issued to the accused persons like Raj Kumar and others. Therefore, they came to. And High Court has stayed the proceedings against the DCP because DCP came there later. DCP has no part in the encounter and JP. Now the matter has come to the Supreme Court. Here, the important point is the cloak of official duty. It can't be extended to the acts intended to thwart justice. So, Honorable Supreme Court of India understood that it is a fake encounter, otherwise they should not have come to this extent. And the DCP who came there, he ordered for the removal of the plates. Why? To destroy the evidence, to screen the evidence. So removing number plates, it is also enough. It's not a part of official duty. So he cannot also get exoneration under section or sanctions necessary under 497 CRPC. It is obstructing the justice and falls outside the scope of the so-called discharge of official duty. If it is done in the discharge of official duty, it needs sanctions. But here, when they are going in plain clothes, when there is no prior information, and when they surrounded a person, killed one single individual by the entire police party, it's not in the discharge of the official duty. It is extra act by police. So therefore, no sanction, you have to face the trial. So prosecutors and police officers, be careful. That's why whether you wear the uniform or not, nobody is saying, but you have to at least make a record that you are in uniform, you are asked him like that. But here the public saw the incident. This is another fact that also has to be taken into consideration. So anyway, study it as a case study. For defense, it will be very, very useful. So the points you jot down and definitely you will be enriched with the legal knowledge. Thank you very much.